All right, I think we're live. Hopefully technology works. I like technology better when it works. So welcome everyone, good morning. Thursday again, and it's time to talk about employment law. I'm Lior Samfiru of Samfiru Tumarkin, and with me, of course, my colleague Lumi Punja. Good morning, Lumi.
Good morning.
And we're glad you join us again. You know, the purpose of these meetings is to talk about some things that I think are going to be interesting and impacting anyone that's working, wants to work, lost their job. You need to know your workplace rights. We're talking about relevant things. We don't lecture on the law, just things you really need to know. And today's a perfect example of this. We're going to talk about employment agreements, contracts of employment, the document you get when you found a job. And those are extremely important documents, and most people don't realize just how important it is. So we're going to tell you what you need to know about them, what to look out for, how to even negotiate those. We're going to go through various things today, specific terms in employment agreements that you have to watch out for, termination clauses, clauses that allow the employer to essentially make your life miserable, non-competition provisions. We'll go over all that today and hopefully give you something to think about if you're looking for work, if you're being offered an employment agreement, things that are really you have to know about. And you know what happens, we find when someone's offered an employment agreement, usually that's a very good thing. They're very excited, and they're going to focus on certain things in that agreement. If you're like most people, you're offered a job, you're going to look at salary. You're going to look at vacation. You're going to look at bonus. And of course, those things make sense. You should look at those. But we're here to tell you that there's other things that are just as important, potentially more important to look for other than salary, bonus, benefits, etc. And that's what we're going to tell you about today and hopefully open your eyes to it. So before I'll turn it over to Lumi to start talking about specific terms that you have to watch out for, I want to make some general comments about employment agreements. First, this is very important. A written employment agreement almost always benefits the employer. Well, why is that? The reason for that is that the law provides some very extensive protections for employees. They are there whether you realize it or not. But the law also says that if you want to agree to less than those protections, you can do that. And that's what an employment agreement does. It either takes away some of those protections or actually gives them to the employer, which is why, believe it or not, for an employee, it is far better not to have a written employment agreement or to have a very short document. I can't tell you, Lumi, how many times I've had someone contact me with a job offer, and they say, well, I'm very worried, Lior, because it's a very brief document. It's like 1 or 2 paragraphs, and I'm worried about that. It doesn't seem right. And you know, I always chuckle when that happens, and I tell the person, don't be worried about the 1-paragraph agreement. Be worried about the 10-page document with a lot of legalese, because I can promise you that in that 10-page document, there's going to be a lot of things that are going to be unfavorable to you, whereas with a 1-paragraph document, there's really not much that an employer can put in. So if I'm advising an employee, you're far better off having a brief document, a brief employment agreement that outlines your job and your salary, and that's it. Unfortunately, employers are getting wiser, and for an employer, certainly, it is far, far better to have a written employment agreement. In fact, if I'm putting my employer advisor hat, I'm saying an employer should never have an employee start working without a properly drafted written employment agreement. So again, depending on your perspective, employee or employer, written agreement can be good or bad. The other thing I'll say about an employment agreement is drafted by lawyers. So they're drafted by people with more legal knowledge than the layperson. So if you're a layperson trying to understand what a lawyer drafted, you're at a disadvantage. And that's what we're here to do today, try to even out that playing field a bit, try to give you some of the information that you need to understand what a lawyer drafted. The final thing I'll say about employment agreements before we start talking about specific terms, this is what I call a rule of thumb. And that is, if you sign it, you have to live with it, okay? It's very, very important. You never sign an employment agreement thinking, who cares, or maybe it's unenforceable. No, if you sign it, you have to live with it. And an employment agreement not only is going to be with you while you're employed, it can also be with you for years after employment comes to an end. We'll give you examples of that. So it's a very, very important document. You have to pay close attention to it. So With that said, we're going to start now talking about certain terms that you have to watch out for other than your salary and your vacation. And with that in mind, I'll turn it over to Lumi.
Yeah, so you mentioned the fact that when we represent employers, the first thing we do is we make sure that our employer clients have termination clauses in their contracts. On the flip side, when employee clients contact us, we breathe a sigh of relief when there is no contract, or when the contract is short and does not contain a termination clause. Why is that? We know, and Lior just explained, that termination clauses are bad for employees. Termination clauses are put in contracts with the specific intent to limit someone's termination entitlements. And so it's better not to have a termination clause in your contract, and it's better not to have, if there is a termination clause, it's better not to have a termination clause that references the ESA, the Employment Standards Act, which is provincial legislation that limits employees' entitlements, that stipulates the minimum standards for employees. And so termination clauses are put in the contract, again, with the intent to save employers money and to limit their exposure to liability. And so that also means that termination clauses take away money from employees. Now, very few contracts, well, very few cases that cross our desk involve employment contracts. Of the employment contracts that cross our desk, very few contain enforceable termination clauses. So just because you happen to have a contract with a termination clause in it, don't assume it's enforceable. Again, as Lior mentioned, without an employment contract, employees have very extensive entitlements at common law, termination entitlements at common law. And so in that case, when the termination clause comes in, it limits those entitlements. There are many examples where a termination clause makes a huge difference, monetary difference for our clients. For example, someone with 2 years of service who is 55 and is a plan manager, for example, with a proper enforceable termination clause, the termination entitlements are 2 weeks. Again, a lawyer who knows what he or she's doing, makes sure that that person doesn't get more than two weeks for 2 weeks in total. Without a contract, in the example I've just given, the termination entitlements are quite significant, 6 months. So there's a huge difference between 6 months of notice or termination pay and 2 weeks of termination pay. For someone who makes $50,000 a year, for example, the difference is, I don't know, $20,000 or something like that. On the other side of the spectrum, someone with many years of, let's say more than 2 decades of service, an enforceable termination clause limits them to just slightly more than 8 months of pay, potentially, where you're looking at 2 years worth of entitlements. So again, huge difference between at a salary of $50,000 a year. There's a huge gap between $100,000 and just over $30,000. And so again, termination clauses are bad for employees, but do not assume that just because you have a termination clause in your contract, there's nothing that can be done. To the contrary, contact a lawyer, call us, and we actually specialize in attacking termination clauses. And getting around termination clauses that on their face seem proper. Termination clauses, in order to be enforceable, have to be very, they have to contain very specific, particular language. And so we recognize right away when there are deficiencies in those clauses and when we can attack and get around.
Yeah, and it's exactly right. If you're looking at an employment agreement that talks about termination of employment, your agreement addresses that. That's a bad thing. The point, the purpose of that is to limit your entitlements. And if it's properly drafted, I can guarantee you at some point that's going to cost you tens of thousands of dollars. So it's always a bad idea. And I know it sounds strange to think of termination of employment when you just started a job, you just got a job offer. But that's the time, maybe the only time to think about it, because that's when you can still do something about it. You don't want to find out 5 years later if there's a restructuring and you're let go, that when you started working 5 years ago, you agreed to a termination clause, and now you're going to get 5 weeks pay instead of 8 months pay. What's that going to mean to your family if you lost your job and you're not going to have a job and you're not going to have an income, you still have to pay your bills, etc. So termination clauses, very, very, very important. Literally, we're talking tens of thousands. Sometimes it could be worth hundreds of thousands of dollars, depending on your income and how long you've worked there. So as Lumi said, be very watchful and mindful. Frankly, when we review an employment agreement, usually we take the document, we flip to the last page or the second last page, and the first thing we look for is a termination clause because it's that important. So do the same thing if you're offered a job, look for those. Now, moving on past termination clauses, let's talk about some other terms that you have to watch out for. The second category is what I call restrictive covenants. These are terms that limit what the employee can or cannot do after employment comes to an end. A big one most employers or employees have heard of is a non-competition obligation. A non-competition obligation tries to prevent an employee from working for a competitor for a period of time after employment comes to an end. So let me share a secret with you. For the most part, these are not enforceable. Our courts have said that we don't like things that prevent someone from earning a living. So unless we're talking about a non-competition obligation is not enforceable. So you may think, okay, it's not enforceable, so who cares? Let's go talk about something else. Well, not so fast. Because remember the rule of thumb, which is if you sign it, you have to live with it. This is what I'm talking about. Now, a non-competition obligation may not be enforceable, but what happens if your former employer tries to enforce it? Well, here's what's going to happen. They'll take legal action against you. They'll take legal action against your new employer. And you know what? 2 years down the road and $100,000 in legal fees later, you will win. But it's going to be a fairly hollow victory. It's not the type of battle that you want to engage in. So in reality, even though an employer cannot necessarily enforce it, they can still make your life miserable. So you have to take it seriously. You cannot sign a non-competition obligation and then just ignore it. A non-competition obligation can be extremely problematic. If you've worked in an industry for your whole life and now you've signed an agreement saying that if you're let go, you can't work in that industry for 2 years, what do? It's a big, big problem. You have to be mindful of that. And honestly, if you're looking at an employment agreement with an overly restrictive non-competition obligation, that in and of itself may be reason enough not to accept the job because the repercussions could be far-reaching. Now, just for fun, let's think about an employment agreement that has a termination clause and a non-competition clause. Well, what's the effect of that? Well, the effect of that is as follows. The employer can let you go at any time, pay you almost nothing. Oh, and by the way, if that happens, you can't work in the industry for 2 years. Now you understand, I hope, why salary is not the only thing that matters. Why, whether you're making 55 or 60,000 may not be as important as some of those things that we've talked about. So it's very important to understand that with a non-competition obligation. Another type of restrictive covenant is a non-solicitation one, non-solicitation obligation. A non-solicitation obligation says that you cannot that you cannot go after your former employer's clients or employees for a period of time. Now, unlike a non-competition obligation, a non-solicitation obligation is enforceable, all right? And with most people may not have a problem with that, but you have to be mindful of it. Where a non-solicitation obligation could be very important is maybe you're in a sales position, you have a book of business, and you broke your employer. Well, if you're let go and you sign a non-solicitation obligation, you now may be unable to access this book of business, and this book of business may be what sustains you. So you have to be very careful and very mindful of that. In some situation, a non-solicitation obligation could be extremely problematic. So again, if you're not okay with it, if it's not agreeable to you, you can't just sign it. You have to think about it, negotiate it, and if it is problematic enough that you think down the road it's going to cause you a lot of grief, you may consider not accepting the offer if you cannot negotiate it. So non-solicitation obligation, something you have to be mindful of. Non-competition obligation, even more so, even though strictly not enforceable. There's also confidentiality obligations in an employment agreement. Usually we don't have a problem with that. The only reason I'm raising those is you may have a 5-page employment agreement, and 2 pages are dedicated to confidentiality, and some people may be worried about that. There's really no reason to. I don't know why someone would take 2 pages to draft confidentiality. Usually the point of confidentiality is that whatever you've learned from your employer that's not otherwise in the public domain, you cannot disclose. But be mindful of non-competition, be mindful of non-solicitation, and we'll talk in a few minutes about how we negotiate those things. But before we do that, there's another category of
yes, and so this next point applies to clauses in employment contract that allow employers to change, to make unilateral changes to your compensation, for example, or job functions, or office location. In the abstract, so in the absence of a clause like this in the contract, unilateral changes to the contract of employment are not permissible on either side, especially on the employer side, the employer having more power in the relationship. And so employers try to protect themselves from this situation by introducing very broad, sometimes very broad clauses that allow them to make changes to their employees' terms of employment in the future and be protected against constructive dismissal claims. So, for example, changes in compensation. Those in the absence of a clause that allows employers to make those changes, it's easier for an employee to claim constructive dismissal if the compensation, the salary, goes down by, let's say, 10 or 15%. With a clause that signed by the employee at the time of the hire, that the employer is allowed to make such a change, obviously the constructive dismissal claim becomes either more difficult to make or impossible. And so make sure you understand what powers you give to your employer when you sign the contracts, and look out for these clauses that just give the employer a lot of discretion. And so I believe that's a good point to keep in mind. And if there's a lot of room for negotiations, right? So if you're not comfortable with how broad the discretion of the employer is, try to bring some scope into that clause at the time you negotiate the contract. It's important to keep in mind that contracts are enforceable if they're signed at the time of the hire, or before you get hired. And contracts that are presented to employees in the middle of their tenure, contracts which try to take away entitlements or rights from employees, they are not enforceable unless certain requirements are met. And so again, if you signed a contract in the middle of your employment, again, assume that it may not be enforceable and contact a lawyer and find out what your rights and obligations are.
Yeah, and then to emphasize some of what Lumi was saying, can you imagine you've worked hard to negotiate terms, you've agreed to your salary, you've agreed to your vacation, your job duties, but you also gave the employer the power to change all those terms. So I ask, what's the point of agreeing to anything? What's the point of agreeing to a salary of $60,000 if you've also told the employer in the agreement you can change it at any time? May as well just take a job and say, hey, just pay me whatever you want and give me whatever job you want. So oftentimes an employment agreement does take that or give that flexibility to the employer to the detriment of the employee. So you want to be careful as an employee. Are you giving your employer the power to change the terms of your employment? Your employer should not have a right to change the terms of your employment unilaterally. It's one thing if you both agree, but not unilaterally. So be very careful of that. See if the agreement says that. If it does, that's a bad thing. That's something that should definitely be deleted. Now, by now, you're all scared. You don't want to ever look at an employment agreement. We'll just sit at home and not work, obviously. Well, that's clearly not an option. So the good news is we're not here to just scare you. We're also here to tell you that you can negotiate these terms. And I wanted to share some thoughts with you about how we go about negotiating employment agreements. Now, negotiations generally, certainly when it comes to employment agreements, oftentimes is about leverage, frankly. It's about having something that the other side wants. And you may think as an employee, well, you know what? I don't have any leverage. I want the job. The employer has the job. So what leverage do I have? Well, let's look at it this way. An employer may go through several rounds of interviews. So after all these rounds of interviews, they've had a first interview, second interview, they've checked references, they've worked really hard. And after this whole long, exhausting process, they found their perfect candidate, you. So at that point, you have something that the employer wants, yourself. That's leverage. And the question you have to ask yourself is, will your employer be willing to lose their perfect candidate, the one they worked so hard to find, because the employee raises some concerns about, say, job security? Oftentimes, the answer to that is no. So remember that. You do have leverage. You have something. You have yourself, your skills, the ones that the employer found to be perfect for them. So because of that, you have leverage. Now, how do we approach our employer? Well, first of all, I'll say you only fight the matter. If you come to us and ask us to review your agreement, we may well point out 15 or 20 things that in a perfect world could be changed to your benefit. Well, what happens, do you think, if you'll go to your employer with that laundry list of 15 things? Well, you'll probably send the wrong message. You'll probably tell them that you're not really interested in the job. That's a bad idea. So what you want to do is you want to take that list of 15 things, for example, and narrow it down to the 2 or 3 things that you really care about the most, and only approach the employer with those things. Maybe it's a termination clause, maybe it's something else, but you want to narrow it down to the 2 or 3 things. And how do we actually approach the employer? Well, the best way I found is to approach them, and usually I like to do this in writing so there's no question about what was said. And first thing I would do is I would reiterate that I want the job and I'm the right person for that job. So employer, I'm very excited to start. I know I'm going to do exceptionally well in this job, and I can't wait to start. That said, employer, I wanted to raise a couple of concerns. And then you list what those concerns are and what you propose. If you do it that way, nothing bad will happen. Your worst case scenario by doing it that way is that the employer may say, no, we can't make those changes, but the job offer won't be pulled off the table. So because of that, there is no downside, okay? So if there's no downside, you should absolutely try. So confirm your interest in the job, and then, of course, outline the issues that you want. There's really no downside or risk in doing it that way. Now, remember what I said at the beginning, that employment agreements are drafted by lawyers. Well, if you think about that, that means that employment agreements are not drafted necessarily by the employer. They're drafted by their lawyer. So the employer may not even know or understand or appreciate what their own employment agreements say because they didn't draft it. So you actually have an opportunity to potentially educate your employer. For example, employer, do you realize that this thing says that I can be let go at any time and get almost no compensation whatsoever? I have concerns about that with respect to job security for me and my family. And an employer may not realize that. It may agree with you, in fact, that that's not fair. So don't assume that just because something is written in the employment agreement that your employer is married to that term. Oftentimes, the employer may not even realize or appreciate what that says. So that's a valuable information that you have to educate your employer. So approach them in a respectful way, confirm your interest in the job, and only fight the battles that matter. And ultimately, if you can't get the changes that you want, you have a decision to make. You may decide to still accept the job or not. I've certainly had clients over the years that cared strongly about, or so strongly about certain terms that they decided to walk away from the job. That's a personal decision. But we're here to tell you that if you at least don't try to negotiate those terms, you're missing out, because in many, many cases, you're able to make those changes. And by the way, that's true whether you're dealing with small employers or large employers. So you should always try. Keep in mind some of those thoughts I just shared with you. And probably the best advice is, before you negotiate, you actually have to understand what you should be negotiating. You should be understanding what the terms are. You can't negotiate something you don't understand. So give us a call. Help us, explain in plain English what your agreement says. Oftentimes they're drafted in a way that's not obvious, or that can be confusing or complicated. So we can hopefully, explain it in a way that makes sense. And once you know what the agreement says, it gets much easier to negotiate, because now you know what you need to negotiate.
Just a very practical point to make. If certain promises were made to you during the negotiations, right, and you don't see those points covered in the contract, make sure you negotiate those points again, or make sure that you confirm that make sure you bring those promises in the contract, within the four corners of the contract, so to speak, because that's the only way to make those promises enforceable later. Right. So if, for example, you were promised a bonus, significant bonus 6 months in, but it's not in the contract, make sure you bring that term in. Again, otherwise, a promise is just that, an empty promise, and you can't rely on it later.
Well, as I like to say, if it's not in writing, it doesn't exist. So if they've made you promises, that's an excellent point. Those have to be incorporated in writing. And if your employer won't do that, then you cannot count on it. There's a reason why they wouldn't put it in writing. So if they promised you a raise, they promised you a bonus, they promised you a promotion, whatever it is, that has to be in writing. Otherwise, it means nothing. So keep those things in mind. Contact us with employment agreements. If you lost your job, of course, give us a call. Over 90% of people that we speak with are offered severance offers that are pennies on the dollars, a lot less than what they're owed. So we always look forward to talking to you, and we look forward to coming back here again in 2 weeks. So thank you, and enjoy the rest of your day.
Thanks. Bye.